Imagine the shock and outrage. A massive corporation using the voice of a legend without permission. That's exactly what the Johnny Cash estate is alleging in a recent lawsuit against Coca-Cola. Prepare to dive into the details of this legal battle, where the lines between imitation and infringement are blurred. Coca-Cola, that global beverage behemoth, is facing some serious heat. The estate of the iconic Man in Black, Johnny Cash, has filed a lawsuit claiming Coca-Cola illegally exploited Cash's legacy by employing a soundalike in one of their commercials. The lawsuit was officially lodged in Nashville federal court on a Tuesday, alleging that Coca-Cola violated Tennessee's right of publicity law. This law basically protects celebrities from having their likeness or persona used for commercial gain without their consent. The core of the issue? A Coca-Cola advertisement centered around college football titled "Fan Work is Thirsty Work." The Cash estate argues that Coca-Cola hired a tribute singer who sounds remarkably similar to Johnny Cash to perform the backing music for the ad. The estate claims that this deliberate imitation misled consumers into believing that the Cash estate endorsed Coca-Cola's products. They even point to social media comments as evidence, highlighting how many people notice the striking resemblance. But here's where it gets controversial. Is sounding like someone enough to constitute infringement? Coca-Cola hasn't officially responded to the complaint, so their defense remains to be seen. However, the lawsuit emphasizes that Coca-Cola never even attempted to secure a license from the Cash estate, despite allegedly capitalizing on Cash's unique and recognizable voice. The lawsuit quotes directly, stating, "Despite capitalizing on the intrinsic value of Johnny Cash's legendary voice, Coca-Cola never even bothered to ask the trust for a license." To bolster their case, the Cash estate is referencing a landmark 1988 ruling involving singer Bette Midler and Ford Motor Co. In that case, Ford used a soundalike in a commercial without Midler's permission, and the Ninth U.S. Circuit Court of Appeals ruled in Midler's favor. This precedent suggests that using a soundalike to evoke a specific celebrity's persona can indeed be a form of infringement. And this is the part most people miss. The legal concept at play here is the right of publicity, which differs from copyright. Copyright protects specific works, like songs or recordings, while the right of publicity protects a celebrity's identity itself. This means even if the soundalike wasn't singing a Johnny Cash song, the sound of his voice, if it's distinctive enough to be associated with Cash, could be protected. The Cash estate is seeking a court order to prevent Coca-Cola from further airing the ad and is also demanding unspecified monetary damages. The case is officially titled John R. Cash Revocable Trust versus Coca-Cola Co., U.S. District Court for the Middle District of Tennessee, number 325:CV01373. The estate is represented by Tim Warnock and Keem Barger of Loeb Loeb. As of now, attorney information for Coca-Cola is not yet available. This case raises important questions about the use of soundalikes in advertising. How close is too close? At what point does imitation become exploitation? And should companies be required to obtain permission even if they're not using a celebrity's actual voice or likeness, but simply mimicking their style? What do you think? Does Coca-Cola's use of a Johnny Cash soundalike cross the line? Is it fair to protect a celebrity's vocal style under the right of publicity? Share your thoughts in the comments below. It's a complex issue and your perspective is valuable.